Greetings, folks. Joe Jarrett here, your instructor for this fall. And of course, this course is Risk and Emergency Management. And we'll kind of bounce between the two, bounce back and forth between risk management and emergency management, although they are connected. Nevertheless, it's important that you understand the distinctions between the two. So we'll start out with risk management. And when you're talking about risk management, of course, especially from a public sector standpoint, but even in the private sector, you're basically trying to either eliminate outright or reduce the risks that are posed or can threaten your organization. And risks can come, of course, in a multitude of ways, everything from people slip and falls, accidents because of the vehicles you've put on the road. If you're a law enforcement agency, excessive use of force or wrongful use of deadly force, slip and falls in buildings that are unsafe. So there's a myriad of them. But basically, as the risk manager, a job is to identify those risks, essentially assess and review them. Then you try to control them, mitigate them as best you can. In other words, reduce their frequency and severity, and then monitor your activities. And that's what you're expected to do as a risk manager. So when I first started out in risk management, oddly enough, it was when I was in the military, and you would think that really the only risk you're worried about there is staying alive or, blowing things up. But nevertheless, we got certified as officers to try to minimize risk to equipment, of course, to human life, to when we were abroad in certain countries, trying to mitigate the risk to their national monuments or religious sites. So I early on was exposed to risk and emergency management. Then ultimately, when I got out of law school, I was hired by Manatee County, Florida, as in a dual role. They hired me as soon as I passed the bar. They hired me as an assistant county attorney and as the risk manager, which was interesting because I thought I was going there just to practice law and try cases. But nevertheless, they also had me running an entire department. A risk management department can have all kinds of personnel involved, a wellness nurse, claims managers, people who evaluate claims, who process the claims, your safety manager, who's actually out there on the road. She or he is out there looking for safe, violations of the safety code, etc. So right off the bat, I was involved in both the legal and practical aspects of risk management. And then when I got to Polk County, Florida, where I was hired as the county attorney, I was also the legal advisor to both the county risk manager and the emergency management facility. And as you can imagine, our program there dealt mainly dealing with the myriad of hurricanes we were constantly facing. And then when I came to Knox County, Tennessee, where I became the Knox County Law Director, which is another way of saying Chief Legal Counsel of the county, representing the Board of Education, the County Commission, and all the constitutional officers, I likewise helped supervise and train their risk management program to ensure, again, that we did have unnecessary or excess risks. You have to remember one thing in risk management. You can't protect yourself against every single type of exposure. Over the years, I've seen people sue the county. For instance, when I was in Florida, we had a guy who was fishing. He tried to catch a bull shark. It pulled him into the water and bit him. Luckily, he survived. So he sued us, saying that we should have had buoys in the bay that would signs basically telling you not to pull bull sharks into boats. We had another genius who decided to try to pull a 12-foot alligator out of the lake, and of course the alligator pulled him into the lake with disastrous results. So these are the kind of things you find in your risk management manual. So you have to remember you're dealing with human nature, and that means risks can come at you from all different avenues. But when we talk about risk management, this profession, and it is a separate profession, basically you're trying to either avoid risk altogether or transfer it to somebody else or minimize that exposure. So again, you can't eliminate all risk. If you're a city or county government, you're going to have vehicles on the road. You're going to have people working on power lines, digging ditches, building buildings, and just basically working in various offices. Injuries do occur, things occur where you basically become effective as a risk manager is to identify these things, look for recurring risks. In other words, why is this one department constantly having these same kind of injuries? and then you then try to take steps to work on those. So you're identifying your exposure. What is my exposure? Well, if you're a risk manager in coastal Florida, hurricanes is going to be one of your great exposures. If you are a risk manager in Tennessee, we have straight line winds, we have flooding, we have wildfires. So you're trying to say, okay, where can these exposures occur? What are my alternatives to these exposures? Can I move a building in a certain place? Can I harden it? In other words, have better construction? Can I not do some of the things I normally do? For instance, rather than allowing private citizens during the 4th of July to use a county park and set off fireworks, maybe we should say, you know, you're going to have to go somewhere else. We're going to avoid that risk because it's too great. And then, of course, basically implementing your risk management methods, and we'll talk about those, and then ultimately evaluating your program. It's worthless if you have all these great policies in place if you don't follow up every few months and say, are they working? Do they have to be adjusted? So we also now have something that's evolved over the few years called enterprise risk management. And what you're basically trying to do there is, rather than having risk management as this separate little silo or separate organization that only handles risk and kind of stays in its own backyard, it permeates everything in the organization. You're basically trying to train everybody to be risk conscious and to buy into the risk program and understand how they could negatively affect the insurance, the budget, etc., by not being safe and secure in their workplace. So again, you're looking at all of these different opportunities, and you're trying to find a program by which you can include your wellness program, workers' compensation, and all the things that can affect risk management. So the risk manager, what do? Well, again, as I mentioned earlier, you're going to have this comprehensive program where you're going to try to identify risks and determine what your response is going to be to those risks. And basically, you may have, depending on the size of your organization, a safety manager who actually goes out on the road looking for hazards and investigating them. Claims adjusters, and a claims adjuster means this. Let's say you are the risk manager for a city in Tennessee and an injury occurs. Someone calls and says, hey, I just had a car accident because your stop sign was down. Nobody ever bothered to put it back up. I'm going to sue you. Well, your claims manager is going to look at that, review it, determine whether or not it's something the county should settle, and will adjust that claim. In other words, make an offer of settlement. Sometimes people take them, sometimes they don't. Also, you'll be purchasing what's called excess insurance. Most cities and counties in Tennessee and most of the state are what we call self-insured. That means every year they set aside money from the budget to pay out claims that are valid. But you don't want to have to pay out for certain catastrophic loss. Let's say, for instance, you build a new courthouse. You're not going to self-insure that because that thing may cost you $100 million to build. So you will contact a private security provider, insurance provider, like Zurich Insurance, and you buy an excess policy. And the way that works is you'll say, okay, look, we will pay for the first $100,000 in damage, but after that, you're on the hook for it, and that's why we're paying you these big premiums. So again, it all works together to ensure the bottom line. The recurring theme here is you either have to avoid the risk, mitigate the risk, and then find a way to settle your claims quickly, efficiently, and hopefully cheaply. And if they have to go to court, they have to go to court. But what you don't want to do is settle frivolous claims. I've worked in places where their policy was, look, this is chump change, just settle it. Give them a couple $100, they'll go away. My attitude was no. We're the government. We don't give away public money. If it's a frivolous claim, let's take it to court and get rid of it. I'd rather spend the money in court litigating these things, because then the word gets around. People know, hey, they're not a soft touch. Don't bother messing with them unless you have a real claim, because they'll take you to court, which most personal injury lawyers hate. So again, there are certain things, when we talk about basic risk management principles, there are certain things you're going to have to do. You're going to have to accept the risk. Too bad. If you're running a jail, you're going to accept the risk of inmate health care, inmate violence, excessive use of force by corrections officers, or if you have a law enforcement agency or fire or EMS, those all come with risks. You accept that. What you do want to make sure is that they don't act recklessly, but you just say, okay, this is the part of doing business. It's like being a school system. You can't say, we're going to have a school system, but no school buses because they're dangerous. No. you're going to have those. You're accepting the risk of bus drivers and car accidents and children getting injured. Now, there are times when you can avoid the risk. I recall once when I was a risk manager in Florida, one of the commissioners was really hot on creating this skate park for skateboarders. He goes, we need to build a skate park. It'll be great for the kids. And I said, wait a minute. And I gave him a study on it, how those can be very dangerous, how they attract predators who like to prey on the kids. When is it going to be open? How are you going to mitigate the damage? You see how these kids fly through the air. So sometimes you just have to say, we're not going to accept that risk. No. Or you try to transfer the risk. And one way that you transfer the risk basically is, again, through insurance policies or a contract or what we call a hold harmless agreement. So let's say somebody says, look, we really want to use your school building or your city county building on a Saturday. We want to use just your big conference room there to have a meeting. Okay, well, you're going to sign this hold harmless agreement, which means you're going to, as it implies, you're going to hold us harmless for anything that occurs during that time. Now, we'll have security there, but if somebody gets hurt, if somebody damages the equipment, whatever, you're going to pay for it. So you transfer that risk to somebody else. And then you try to mitigate it. And basically, you do that with your own people. You educate and train them how to act safely. You have enhanced safety measures, operating procedures, and everything from something as simple as putting up signs can protect you by mitigating your risk. Just telling people, look, you do this at your own hazard. Now, depending upon where you live, that could be a little tricky. I recall that when I was in Florida, I was more in the central Florida area, but a friend of mine, she was the risk management director for Miami, and a federal judge down there said, look, if you're going to put up signs to warn people, they better not just be in English. They better be at least also in Spanish and Haitian Creole for the Haitian population and for the Hispanic population, especially the Cuban population. So just putting up a sign in English in an area where it's 90% Hispanic or Haitian isn't going to cut it. But again, signs can be very effective. Telling people, do not go here. Telling people what they cannot do. And of course, people will ignore these signs anyway, but at least it shows that look, we knew there was a hazard, we did our best. And sometimes people will sue you anyway. They'll look at your sign, say, there's no sharks out there, or I've never seen an alligator before, or hey, I'm a safe scooter rider, and then they sue you anyway, and that's where you have to turn it over to the attorney, staff, and say, go to court, please. And again, people will sue just because they know they can sue, and they're hoping you'll settle quickly, give them some money, even if it's a frivolous claim. And I've already told you my philosophy on that. No, see you in court. Now, you may have heard of this term sovereign immunity, and even lawyers sometimes get confused by this, but the bottom line is, when we first brought over our laws from England, the king or the queen was considered the sovereign, the government. And it translated the same way in this country, even though we never had a king. The sovereign meant the leader, the head and rule of government. And for the longest time, the sovereign said, or the government said, we're immune. You don't get to sue us. And it's only been a few years where the states, local governments, and even part of the federal government said, okay, we are the government, and technically we are immune from lawsuit. But we will waive part of that immunity to allow you to sue us for certain things. So there are certain things you can sue for in government, and then there are certain things they still say, too bad, so sad. For instance, you can't sue a judge. If you go to court, the judge says you're guilty, you go to prison, 10 years later you get a DNA test, and they say, whoops, wrong person, too bad. You can't sue the judge. There they say, no, we have absolute immunity, too bad. But other times, in other instances, the government said, okay, in these particular instances, you can sue us. And basically, in Tennessee, if a citizen is injured because a county or city or state employee negligently operated a motor vehicle, you can sue. If the city, state, or county has unsafe streets, sidewalks, traffic control devices, they're subject to being sued. Dangerous structures, let's say the city goes, hey, let's put up a nice playground for these kids, and they do it improperly or negligently, they can be sued. And acts of omissions or omissions of employees. So either an employee did something negligently, like was driving negligently down the road, exceeded the speed limit, ran a stop sign, and hit you as you were driving, or they omitted to do that what they were supposed to do. They were supposed to put up warning signs because there was a huge pothole, or they were to repair a signal light they kind of forgot to do, or put up a stop sign that had been knocked down. So it's either something they've done negligently or they omitted to do that which they're required to do by law. So here's a couple of geniuses here. You can't make these things up. People do these kind of things. You can see the guy under there, and kind of he has his own kind of makeshift jack. That's probably not going to end well. I actually saw something very similar to this once, not as dramatic, but I went in one day to the Animal Control Center in Knox County, and this guy put a ladder upon a ladder upon a ladder, and he was bouncing on one foot. Not good. And of course, these characters here. So people can be very inventive in doing stupid things and cause you to get sued. Now, you may have heard the term liability. And again, if this sounds like I'm being a little pedantic or basic, I don't really know the experience level of folks, how much exposure they had to the law, so just bear with me. But when we talk about the elements of liability, you'll also hear the term is the city, the county, or the state, is the government liable for that action? So from liability, are we liable? And what are the elements somebody's going to have to prove? See, this is not a criminal case. This is not where the state has to prove something beyond and to the exclusion of every reasonable doubt because it's a constitutional issue involving a crime. This is civil law. So this is a whole different standard. So the person bringing the lawsuit has the burden to prove that they were injured by the city or the county. So first of all, the first three elements we're going to talk about, or the three elements I should say, was there a duty? Did we breach or did we not improperly do that duty? And was that the cause of the person's injury? And as a result, so did we have a duty under law, rule, regulation, or a standard of care to do something? Did we have a duty to fix that pothole? Did we have a duty to make that sidewalk safe in front of that elementary school? Is it Tennessee law? Is it just a standard of care? See, anytime the government endeavors to do something, if the government says we're going to do this, whatever it is, even if they don't have to do it, they're just doing it because they think it's a great idea, like putting in a public swimming pool, they have to do it non-negligently. They can't be negligent. So was there a duty to a person? Did we breach that duty? In other words, did we do something foolish or improper, or did we forget to do something or omit to do something we should have done? And can you connect the two? So if we have a duty of care and we breach that duty by an act or omission, and that caused someone's injury, well then we're liable. But again, it gets a little iffy. So if somebody finds out we had a duty and we breached that duty, but they were never injured, they can't sue because we just didn't do our job properly. There's got to be an injury. And people will do that. People will say, hey, wait a minute. I just read that the county has to put up these signs for wheelchair ramps. They didn't put those signs up. I'm going to sue. Well, no. You can sue all day long. The court's going to dismiss that because you weren't injured. If, however, they were supposed to put up a sign warning you about something, failed to do so, and you could connect that duty and that breach of that cause, now you've got an injury. Now you've probably got a viable lawsuit. So we call this the negligent triangle. So again, we're talking about civil liability. Who is injured? Who is responsible? And what's that going to cost us? So was there a private citizen injured? If an employee gets injured, that's why we have workers' compensation. Was the employee injured? Who's responsible for that injury? And are we going to have to pay out some money? Now you may say, well, that's a no-brainer. Not always. Sometimes you have, for instance, let's say you have a greenway that's shared by a city and the county. They pool their money together and say, hey, let's create a greenway around the city, through the county. Somebody gets injured. They sue the county. If the county can prove, no, you were injured on city property, not county property, we're not responsible. So you have to prove who's responsible. And when people, for instance, they see a sheriff's deputy, they may not be able to distinguish between the city police department and the sheriff's department. So they may end up suing the city police, who are going to say, sorry, wrong agency, we're not responsible, go sue the sheriff. So it's something as simple as that. But who was injured? Who is responsible for an injury? Are we going to have to pay out? And you have three basic levels. You have simple negligence. This is the lowest level. And that's basically doing something like not repairing a pothole, failing to put up a sign where there's no catastrophic injury. Then you have gross negligence. And that's when you knew, whoops, we better get this thing done before somebody gets hurt. And the highest of this is what we call deliberate indifference. So what's the difference between the gross negligence and deliberate indifference? Well, gross negligence means, we knew we should have put that up, but, we really didn't, how did we know something was going to happen? We kind of knew, but it's such an unused road, we thought maybe perhaps, but with deliberate indifference, you knew definitely if we don't do this, somebody's going to get hurt. It's subtle, but it's enough for a court to make that decision. So, for instance, let's say you're running a jail and you put an inmate in a cell with another inmate, and they're about the same age, they're both there on nonviolent charges. But the other inmate decides to attack inmate A, attacks inmate B. Well, that's probably just, garden variety negligence. But if the other inmate said, hey, look, I don't want a roommate, I don't want a cellmate, I want to be by myself, and you put the other guy anywhere and he gets beaten up, you can say, we should have seen that coming. This guy said he didn't want a cellmate. But a deliberate indifference is when the guy said, you put somebody in here with me, I'm going to bang his head against the wall. You knew. It was foreseeable. It was going to happen. Boom. So my point of all that is it comes down to a money game. The greater your level of negligence is the greater level of your liability. Simple negligence versus gross negligence versus deliberate indifference. Judges and juries do not like deliberate indifference. They're usually fair-minded. They know that the government's going to make some stupid mistakes, but when they see that any person with average intelligence knew this terrible thing is going to happen, government's going to pay for that. So how does the plaintiff attack? Now, when I say the plaintiff, I mean the plaintiff's lawyer. Normally, you're dealing with personal injury lawyers. First of all, they're going to look at the facts of the case, and you think, well, no kidding. But they'll investigate all the facts and circumstances that led up to that attack or that problem or that damage or that injury. Then they're going to look at your policy. They're going to say, do these people have a policy? If they do, are they following their own policy or are they ignoring it? What kind of training are they giving their people? What kind of supervision are they have? And what kind of discipline? So let's say you have something simple as a soccer field. You put up a soccer field and you knew that there was a small sinkhole there, but it was only about a foot deep. You just threw some dirt on top or whatever. So the attorney will say, okay, what are the facts of the case? Oh, okay. Well, they had a damaged property here. They were letting kids running around on, knowing that probably one of them is going to fall into that thing. 2, do they have a policy even covering that? And if they had a policy, are they following their own policy? 3, are they training their people to look out for these kind of things and take immediate steps to do it? 4, who is supervising these people who are out there doing this job? And 5, if you have a person who knew it was out there, didn't follow policy, wasn't trained properly, had a bad supervisor, what kind of discipline are we talking about? Has this guy been doing this or this woman been doing this for 10 years or this person's been doing this for years and there's been no discipline? So these are the kind of things that an attorney will use to attack. So bottom line is, in government, in risk management, if you are on notice of a hazardous condition, the government has a duty to warn, a duty to guide, in other words, get you away from that dangerous place and protect you in that purpose. So it'd be something as simple as there's a damage to a sidewalk. The county puts up a warning sign that says damage or danger, and then they have a path that says follow this detour around it, and we're going to protect you as you're doing it. That's the bottom line. Warn, guide, protect. Again, negligence has 4 elements. We had a duty to act. We breached that duty, in other words, didn't do what we're supposed to do. As a result of the breach of that duty, there was injury, and there was actually an injury. And that just kind of recap what I talked about earlier about negligence. Duty to act, breach of that duty, in other words, violation of it. That was the injury, and there was an actual real injury. When I say actual real injury, that sounds silly, but there are people who will sue for really non-existent or inventive injuries. We had a guy once in Knox County who claimed when he was standing on the corner, he breathed in some bus fumes, and then he was starting to have hallucinations. He was losing his job. His wife left him. He was making it up. So there was no actual injury there. But again, you have to investigate those. And that, folks, is risk management in a nutshell. I hope this helped to give you an idea as you go forward in exploring this area of law and policy, which I think you'll very much enjoy.